Household Retail Services versus the Commissioner of Revenue.
Thank you.
Mr. Larson? Good morning.
Good morning, Madam Chief Justice and members of the Court. May it please the Court, Your Honors, my name is Peter Larson, representing Household Retail Services, Inc. and Household Bank SBNA, which is now known as HSBC. With me is Nicholas Rosenberg of the Edwards Angel Firm. The sole issue on appeal in this case is the legal issue of whether HSBC is entitled to reimbursement of sales tax that it funded on taxable credit or installment sales where the purchasers defaulted on these credit or installment sales and HSBC charged off these debts.
Mr. Larson, General Laws 64-8, Section 33 says any vendor who has paid. Now, is household a vendor?
Under the definition set forth in Chapter 64, Section 1, yes, household is a vendor. Household did not sell the goods at issue in this case.
Well, the definition of vendor is a retailer or other person selling tangible personal property, isn't it?
That's correct, Your Honor.
Well, did household sell tangible personal property?
No, it did not.
So how is it a vendor?
Because the definition of vendor says a retailer or other person.
But a person is defined later on then as one who sells something here.
Well, Your Honor, if that's the interpretation of this definition, then the use of the terms or other person is meaningless, because anyone who sells tangible personal property is by definition a retailer. So why would the legislature...
No, not really, because the definition also includes assignees, and assignees can sell, but your assignee didn't sell. It provided credit.
That's correct, but if the assignee sold, that assignee would also be a retailer, so you still wouldn't...
Be a person. It would be a person within the statute. So it's what your suggestion that the word person is superfluous isn't right.
I would disagree, Your Honor, respectfully, because, again, if the assignee sells, the assignee is a retailer, and the assignee does not have to be another person. And even if...
But couldn't it be a bank that's taken possession of the property and sold it at a distressed sale? Isn't that an assignee?
Yes.
But they're not typically in the... They're a seller, but they're not a retailer in the sense that they're not regularly engaged in the sale of the particular item or any item for that matter.
That's correct, Your Honor. And in this case, HSBC does engage in that activity.
But was this a distressed sale?
No.
No. And doesn't that go to the point, I mean, as you know, the courts are kind of split. So, we've got New York and Michigan and Alabama and everybody. So this is not exactly new or different. But it seemed, how do you respond to the Court of Appeals decision that what the statute does is not tax the seller, it taxes the buyer? And so this, in other words, I pay the sales tax. I'm the consumer. I pay the sales tax. And the transaction is complete upon the sale. I bought whatever it was, the refrigerator, the car, the down jacket. And that's when the tax is due. So there's no windfall here. That's when the tax is due. Some consumer obtained a product, and there's a tax on that. Now, there's a different transaction which has to do with loaning money. I can do it on a credit card. I can do it, through household finance. But that doesn't go to the taxing event. That seemed to me, of all the cases, the most powerful claim here. So what's your response to that?
Well, my response to that, Your Honor, is that first of all, the legislature has decided in this Commonwealth that if a vendor were to finance their own sales, clearly even the commissioner would agree that that vendor is entitled to a bad debt sales tax reimbursement if the purchaser ultimately defaults. Because the theory is that the sales tax is only supposed to be applied on the amount of the purchase price actually paid. And because of Massachusetts' advanced payment system, where in credit or installment sales the tax is paid up front, regardless of how much of the purchase price is actually paid, The bad debt statute fixes that issue.
Let me just, I don't mean to interrupt you, but one way for me to think of it is to say, I go to a vendor. I'm more familiar with clothing than with cars, and I buy my
works with clothing.
So you don't pay sales tax
and
much.
I buy my
Or you do.
down jacket for $200, right? And then I see the next day there's a sale that says I can buy with the same vendor the same thing for $120, and I go back and have a lip-rolling argument with the salesperson to say, this is unfair, and she says, well, you bought it yesterday, and eventually I pay only $150. Isn't that what the legislature is saying? The taxable event, when I got the jacket, I was going to pay $200, but I've decided we've now renegotiated it's only $150. It seems to me that's what the legislature was trying to deal with, not I pay $200 and then go to you to borrow $200, and then I eventually don't pay you your $200. I've absconded and leaving you with a debt. Isn't that the difference?
Actually, Your Honor, there's a specific and completely separate statute to deal with your example, which we call the return merchandise statute.
Well, that's returned.
Yeah, this relates to worthless debt. This is a very different provision, it seems to me.
I would agree, Your Honor. I think this is very specific to, and it's very clear, and again, the Commissioner would agree that if the vendor made the sale and financed the sales price themselves, that the vendor would clearly be entitled to reimbursement under the statute.
Correct. But one of the things about that scenario, a more simple scenario, is that there would be no question that the vendor was the one who had paid the sales tax. And one of the problems here is who paid the sales tax? What is the evidence, if any, that household paid the sales taxes at issue?
The evidence is there's two responses to that question. One is the specific evidence is in the joint stipulation of the parties. It's agreed and very clear that HSBC funded the sales tax. It was HSBC's money that went to the retailer that made the sale that went to the state coffers. But even if you were to take the position, and so from our standpoint, HSBC paid the tax. But even if you were to say, well, they funded the tax, but it was really the retailer that paid the tax, as assignee of the retailers, and regardless of whether you view a vendor as only being someone who sells property, completely separate from the statutory definitions under the common law in this Commonwealth, even if the statute said the person who makes the sale at issue in this case is entitled to the bad debt deduction or reimbursement, any assignee of that person who paid the tax and made the sale would also be entitled to it under the Massachusetts Common Law of Assignment. So, number one, it's our position that HSBC paid the tax because it was their money, which is what in the recent supplemental authority we filed in Alabama, the judge ruled. And with that said, the cases are all over the board in the various states, so I wouldn't draw too much from those cases because although the facts are very similar in those cases, the statutes in the various states are all very different.
What would prevent both the retailer and household from claiming this?
The retailer did not charge off the debt. The retailer who made the sale, if the retailer charged off the debt, would be able to recover. But without a charge-off, there would be no right to recover because the commissioner will require proof of charge-off in order to verify that refund. And that's what prevents double recovery. It's because you have to have charged off the debt, and the retailer can't show that it charged off the debt.
What if the statute, I note that our statute says entitled to reimbursement. What if it had said entitled to be credited against, as some statutes do, entitled to a credit against sort of future sales taxes owed? Would that make a difference? Would that sort of knock you out?
I don't think that it knocks us out. There has been a couple of courts that have thought that it did and a couple of courts in other states that have thought that it did not. There are a couple of court decisions. The Tennessee Court of Appeals decision that both parties cited specifically said that a dealer is entitled to a credit. But the court said, well, whether it's a credit or refund, whether the statute says credit doesn't matter. A party is still entitled to a refund because if you don't have any ongoing liability against which to take the credit, then by definition you're able to get a refund, which would be our position here. But in this case and in this state, it specifically says reimbursement, and there's no question with either the commission or on our side that a refund or reimbursement would be due.
Mr. Larson, the board, I'm looking at the board's finding that although you were entitled to receive the installment payments from the customers, neither the merchant agreement specified where the household acquired the vendor's rights to abatement of the sales tax paid by the vendors. Could your agreement so provide?
They certainly could, and we think that the agreements do transfer all rights.
Right.
If I have a note, if I lend you money, and I have my note, and I assign it to Ms. Spector, she can assert all the statutory rights I have as a holder of note, even if the assignment just says, I hereby assign this note. That's the law in Massachusetts. Otherwise, my assignment would have to say, I hereby assign, and you'd have to list every statutory right that exists under the law. But the specific language of the contract is about as broad as it can get. The language is so small, I'll have to hold it close to my eyes. But it says that the assignee is allowed to take, in dealer's name or otherwise, all such legal or other proceedings as dealer might have taken but for the assignment. It's hard to imagine the language being much broader and not including the right to a sales tax refund. If that were the sole basis for the decision of the board, which was the focus of the board, the appellate tax board, then if that language is not sufficient, we can certainly insert it in future contracts.
Well, I was going to say, I found that somewhat peculiar. I understand Justice Island's question of whether under our drafted statute you are or not vendor. That's a separate one. And then the third finding of the board was because the vendors had the obligation to pay and had in fact paid the sales tax, household was not the person, quote, aggrieved by the remittance of the sales tax at issue. I take it that that really goes back to the first. It's just another way of making the first point, correct?
I agree with you completely. If we are not a vendor by assignment or by succession to the retailers that made the sales, then we wouldn't be a person aggrieved. But if we are, then we are a person aggrieved. So I think it's the exact same test. You either win on both or you lose on both.
Correct.
I don't think they're independent arguments, and I think that really whether you're a person aggrieved just begs the question as to whether you are.
Correct.
Whether you are a vendor.
So let me just make sure I understand that. Are you arguing that regardless of the question of whether you are or are a retail under the statute, you become a retailer because your agreement with the retailer assigned you all the rights of the retailer in the sale?
That's correct, Your Honor. So even if we have two completely separate independent arguments, one is that we meet the direct definition of vendor because vendor defines itself as a retailer or other person, which includes assignees. It also includes, by the way, not just assignees, but any combination of individuals acting as a unit.
But even if you don't meet the statute.
But even if we don't, even if the vendor and person were not defined that way, and it just said the retailer that made the sales at issue is entitled to the reimbursement, we still would be the assignee of the retailer that made the sales at issue and would be entitled to this refund under Massachusetts common law. Because under Massachusetts common law, the tax statute must specifically prohibit assignment. Otherwise, assignment is permitted. And in a couple of states, I think a couple of states have done harm to their own common law of assignment by, on this issue, saying, well, you strictly construe tax statutes, so strict construction prevails over the common law of assignability. And I would plead that this Court not, regardless of which way it finds, adopt that as the test, because you can't take a rule of construction and overturn substantive common law with a rule of construction. You use the rules of construction to define whether or not we are possibly a vendor or not. But once you construe the statute to determine whether we are a vendor, at that point, whoever that vendor is can assign his or her rights to that refund.
And it's your position, Mr. Larson, that once those are assigned, the vendor cannot take a tax write-off?
That's correct, Your Honor.
Okay.
And it
So-
could
so
not.
you can't
Because it couldn't, yeah, right, I'm sorry, because it can't, at that point, it can't take the loss because it suffers no loss.
Exactly. It suffers no loss, can't take the loss, and therefore has no reimbursement claim, and couldn't prove its claim because, of course, proof of write-off is one of the elements you have to prove when determining the amount and validity of your claim that you file. With respect to the person aggrieved, not only is this the law in Massachusetts, but also it's the black letter law. I hate to quote from ALR, but in summarizing what the state of the law is on this issue, they state that in the absence of a statutory provision against assignment of claims for refund against the government, The assignability of a claim for refund is sustained by the weight of authority, and the view is adhered to despite the fact that the provision of the refunding statute authorizes the refund to be made to or to be given to the person aggrieved. This is from ALR, by or making the overpayment of the tax where the statute does not expressly deal with assignability. These statutes actually do deal with assignability in favor of assignability. But even if they didn't, even if they were completely silent, under the weight of law in Massachusetts, HSBC, as assignee, transferee, successor to the rights of these retail merchants, would be entitled to the sales tax reimbursement.
Thank you, Mr. Larson.
Thank you very much.
Ms. Spector?
Good morning. Amy Spector, Assistant Attorney General for the Commissioner of Revenue.
Well, what do you do with the assignment argument that he just made, also makes in his brief? Household was assigned all the rights of the vendor, which included the rights to get the refund. And the vendor, we all concede, no longer can get the refund.
We strenuously disagree with that. The rights that were assigned by the vendor were the rights in the installment contract that the that the vendor had with the purchaser. Those rights included, notably, the right to repossess the property if the customer fails to actually send in the money for the down jacket or the piece of furniture, and the right to be paid for that. The assignment
Didn't it assign all rights under the contract?
all rights under the contract.
Doesn't
but
that take care of it?
He just read some very broad assignment language.
No, it doesn't take care of it. The contract between the vendor and the purchaser is a contractual relationship governing the goods that the vendor provides, the down jacket, and the vendor has the right to receive payment for that. The purchaser gets the jacket in return.
So if there were a claim of breach of warranty, of merchantability with respect to the sale of the jacket, and the purchaser filed a suit against the vendor, vendor says, hey, you've got to implead a third party, the bank, because they, by the nature of the contract, they're the ones that are now susceptible to that particular claim.
Your question is whether they could maintain that claim against the finance company?
They can.
I'm not certain of the answer to that, but irrespective of that, what they're assigning, they can't assign a statutory right to tax relief. For one thing,
No, you're not assigning a tax. You've got a statute that says. Let me do this in two parts. You've just said to me they don't have all of the rights because the vendor retains the right to reclaim the good or to take back the good. Correct?
yes.
But and then may, for all I know, resell it. Correct?
I'm sorry.
May resell it, do whatever it wants to do with it.
Yes.
But what the legislature has said is, let's assume you've got one transaction between vendor and consumer. It doesn't have to always be a consumer, I don't think, but in any event, and there's an agreed upon price, and then for whatever reason, the price is not for whatever reason, but because the consumer doesn't pay the full price, the Commonwealth won't collect the tax on the full amount. That is what is governed by the contract between the vendor and household finance, not what ultimately happens. The consumer, for example, could have given the jacket to somebody else who could resell it. That's not what the Commonwealth is interested in. The Commonwealth is interested in this first taxable event, and that's what's been assigned.
That's correct. The taxable event is the moment when the vendor sells transfers title to the down jacket, to Your Honor, and you pay or you make a binding promise to pay. And what the legislature was concerned with and why they enacted the bad debt relief statute was the situation where, because you purchased it on credit and you then failed to pay, the vendor was then left not only with having to pick up the cost of the jacket, but also having to pay the sales tax. When the legislature enacted the statute, they were concerned with remedying that perceived inequity or unfairness to the vendor. But vendors are completely different from finance companies. Vendors have an obligation, an ongoing relationship with the state. They're required to register. which is an indication to the state that they're going to be making retail sales and filing sales tax reports. The finance company doesn't have this relationship with the state. They don't pay the sales tax.
No, but
And-
if you're looking at the scope of the assignment, I mean, I know, even if the vendor's ledger, if you're looking at the scope of the assignment, if the relief is for whoever acquired the good didn't pay the price that had been agreed to by the vendor, the legislature has provided relief.
The legislature provided relief for the vendor who sold the good and
Why?
who paid this. Why?
Because here the vendor has been paid in full.
Exactly. That's why the relief is not warranted in this situation. The legislature was concerned that it seemed unfair.
But it's unfair to the vendor's
To the
assignee.
No, because
The only reason why the vendor's been paid in full is because in exchange for assigning its rights to go get as much money as it possibly could, it got all of its money and assigned all of its rights with respect to that money, including, presumably, the bad debts relief.
Well, I disagree, Your Honor. What the legislature was concerned with after the Continental Hyannis case was the case of a vendor, in that case, who had financed the
Right.
sale themselves. The vendor ended up, because the purchaser failed to pay, the purchaser defaulted, the vendor had to not only incur the cost of the goods, but also the sales tax as well.
But that's what happened here.
No, that's not what happened here. Here, the vendor paid the sales tax, the purchaser got their furniture, and
But the vendor got the money to pay the sales tax.
that's exactly right. Because the vendor received the money, the transaction is complete. The type of situation that the legislature was concerned about has not occurred here.
But why hasn't the vendor in this case taken off its shoes and assigned them to the bank? And
That-
the bank put the
I'm
shoes
sorry.
on and stands in the shoes of the vendor. He now comes to the tax office and says, wearing the shoes of the vendor, I am now the vendor.
Because you can't be a vendor just for the purpose of trying to get the benefit of reimbursement without the corresponding obligations that fall on vendors,
But
including...
this is their money, isn't it, that paid the sales tax?
No, it's not their money that paid the sales tax. The vendors paid the sales tax to the
Well, using
commissioner.
whose money?
With the vendor's money. The vendor is the
And
only...
where did that money come from?
Well, it came from other sales. It came from their general pool of funds. But they...
What do you mean? I mean, if you bought a refrigerator and they financed it,
Well,
I-
money is fungible.
I take
Money
it,
is fungible.
I take it, Ms. Spector, your argument goes something like this. I'm buying the refrigerator, right? One way I buy the refrigerator is I go to my local bank, and I say, I'm going to borrow $800, and I'm going to take the $800, and I'm going to enter into, a loan agreement, and I'm going to take my $800, and I'm going to go to the vendor, and I'm going to give the vendor the $800. And the vendor pays the sales tax.
Exactly.
That's
Here,
not this
in order
case.
to be customer-friendly, the vendor says, instead of going to your bank, Marshall, we've got this nice agreement with Household. It's a bank, but because we send them a lot of clients, they give you a better deal. But they're really a bank. And so what you do, you go to Household and you get your $800. It's linked to the same thing. You pay the vendor. That's your position, correct? That they are essentially a bank, and the fact that they do it together with the vendor makes no difference.
Yes, that's exactly right, because they don't function as a vendor. They don't register in Massachusetts. They don't pay the sales tax. Presumably...
Can I follow out where that goes here? Because this is just conceptually. Let's say there's a very successful furniture store in Massachusetts. Maybe its name starts with a J.
I thought it was going to start with an I, but that's no.
And it finances a lot of its own sales and finds that that's actually a pretty good market, and they have a lot of business, and so they determine that they actually could do this financing for other furniture companies that may not have the resources. So instead of going to Household Finance, their finance arm within their retail operation reaches agreements with other vendors of furniture that they actually will do the financing. This store, which not only sells but finances, will do the financing for other retail stores. Now, what happens then? They are a vendor. They didn't sell this furniture when the debts collapse. They didn't sell that furniture, but they are a vendor.
I don't,
They're not a vendor for purposes of loaning the money to the consumer
Right.
who's buying the furniture down the road at the iStore.
the iStore. I don't believe that Jordan's Furniture would be able to get the relief in that situation. The situation where I think.
So you're saying it's not just the status of the borrower, I mean the lender, even if it was a retailer, if it did not sell this merchandise, it is not a vendor.
Well, yes, or unless they completely took over it. For example, if Jordan's was so successful that they drove the iStore out of business, essentially. They were always having these Columbus Day sales and whatnot, even not on Columbus Day. And they succeeded to the entire business of the iStore. That is, if they got their assets and liabilities, then I think they would fully step into the shoes of the iStore.
But I take it that would be the same for a bank. If a bank foreclosed on a whole series of corporate notes and took over, and the business was sort of voluntarily surrendered, or the bank took over the business to liquidate it or to sort of gather up its assets and liability. I mean, is that the same thing?
Well, they would have to be, I mean, again, the benefit goes with the obligation to pay the sales tax. So in the situation with Jordan succeeding to the rights of, I'm sorry, I'm not actually sure what the iStore is, but I guess I haven't bought furniture.
Must be in Cambridge.
Oh, okay. Okay.
Actually, IKEA is right next door to Jordan's, and it's
I was
not
thinking
in
outside. Okay.
We don't
I
have,
obviously haven't
we
been
don't have
shopping
chain
enough.
stores in Cambridge, you know that.
In the situation where they succeed completely, I'm thinking maybe it might be the opposite. And, Jordan's might get absorbed by the iStore, but the entity that takes over, would presumably pay sales tax, for example, on furniture that had been sold, but the sales tax hadn't yet been paid. So where they had the benefit goes with the corresponding obligation to pay the sales tax, to file returns, to register with the state. The finance company has none of those obligations and is simply seeking to be a vendor, in essence, for one portion of the statute without having any of the obligations that flow with being a vendor.
Could you just turn to the definition within the statute, because we don't have to get, I mean, why is a household not an S&E as defined in 64H1 person? In other words,
they may be an assignee, but they're not an assignee. They're not a vendor. The definition of a vendor is a retailer or other person selling tangible personal property of a kind that is subject to the sales tax. They're trying to essentially read out the language selling tangible personal property.
No, but if I'm selling tangible personal and I assign, what am I assigning? I can only assign to.
Well, in this case, what they're assigning is the right to recover from you for the down jacket or for the piece of furniture, and they're also assigning the right to repossess that item if the customer fails to pay.
The definition of S&E is seldom. You stand in the shoes of. You don't have the same shoes. In other words, it seems to me that your argument is circular, that in order to be an S&E, you have to be a vendor. If you're the S&E of a vendor, you're not the vendor.
No, in order to be a vendor, you have to be an entity that both makes retail sales and that collects and pays over to the commissioner a sales tax. You can be an S&E and not be a vendor. That's the issue here. That's what household is. They have by assignment acquired some of the contractual rights that the vendors had vis-a-vis their furniture customers. Those are the rights that household acquired.
Yeah, I mean, what you're doing is you're looking at the technical words of the statute. You may very well be correct, which says you've either got to be a vendor, as a retailer who sells things, stores, so on, or other person. selling, and an assignee can be another person as long as they're selling, correct? And household isn't selling.
They're not selling, that's exactly right.
So technically applied, they're not selling anything. They're not selling tangible personal property or selling services and so on. So just on that basis, you win.
Yes, I agree. That's correct.
Even though it does create something of a windfall for the state, but so be it.
No, it doesn't. I want to address that argument. It does not create a windfall from the state. And I think the argument that it does create a windfall rests on, again, a misconstruction of the purpose of the sales tax and on what the legislature had in mind when they enacted the bad debt relief provision. As Your Honor, Chief Justice Marshall recognized, that sales tax is a transaction tax on the sale, on the exchange of property.
Yeah.
The vendor gets the receipts either in the form of cash or a promise to pay. The customer gets the goods. That transaction is completed in the situation where...
It is completed until the legislature passed this nice little statute and then said, it's completed, but if you don't get all your money, you get relief. And the question is...
Right.
Well, it really doesn't matter whether it's a windfall or not, because no matter how broad the assignment clause is, that definition that you have to be an assignee who sells is never met, because you don't sell.
No, that's only if,
Well,
that's only to
correct.
fall within the definition of the statute. You can be an assignee under the common. I mean, the household makes two arguments. Either I am literally a person under the statute.
If the bank were liable for any breach of warranty to the purchaser for the products that are involved in this retail business, would your view change?
First of all, I think I may have misspoke earlier. I think that they don't. They're not responsible for the quality of the merchandise and so forth. But I don't think it would
But if
change
they are,
because,
if
they still wouldn't be a vendor. They still wouldn't be paying the sales tax. Again, they're still trying to come in and get the benefit of the relief without the corresponding obligations of being a vendor in Massachusetts.
Ms. Spector, let me ask you just one more question. You alluded, I think correctly, to the fact that this statute was enacted in the wake, somewhat many years later, but nevertheless in the wake of a decision of this court. But the facts in that case happen to have the vendor as the financer as well, correct?
Yes, correct.
Is there any reason to think that, I mean, I've heard your arguments that it's vendor, but I still can't get past the fact that the transaction is finished, but then if the consumer doesn't pay, whoever there's relief in the form of tax relief, and it seems to me that for the Commissioner to take the position that it makes a difference if there's been an assignment is not consistent with what the legislature really intended, which was not so much to protect vendor qua vendor, but to protect the person who had paid sales tax on $100 when that person had only received $50. And
Well,
here the person has only received $50. The person is an assignee under the common law, but only $50 was received from the purchaser.
Well, with all due respect, Your Honor, I think your question suggests the answer. It's only, the legislature wasn't rigidly concerned with the word vendor, but it's what a vendor means under the sales tax statute. It's only the vendor that's paid the sales tax, and that's why the relief is only directed at the vendor. It's only the vendor who, although in Continental Hyannis it was the vendor who made the financing, that's the same entity that paid the sales tax to the state, and that's the situation that the legislature aimed at addressing.
Thank you, Ms. Victor.
Thank you.